Welcome, everybody. My name is Justin Gitelman. I am the Expert Content Partnerships Coordinator here at Levelset, which means that I work with all these experts in our Ask an Expert Center to get them into the webinars just like this one. And basically, we're going to have a webinar today on extended duration claims with our guest speaker here, David Vicknair from Scott Vicknair Hair and Checki in New Orleans. He's an expert here on the Expert Center. We're very happy to have him here. And for those who don't know, the Expert Center is a place where you can ask a payment question about construction and get an answer from a construction attorney or industry expert in your state any day of the week. So go ahead and ask any questions that you have there after this presentation, or if you're tuning in live here, feel free to chat in and ask, and hopefully David can give some insight. So without any further ado, David, take it away.
Thank you, Justin. I'm excited to be with you all this afternoon and have a brief discussion on extended duration claims. I was just joking with Justin. This is the type of seminar I could probably talk for about 3 or 4 hours on, but I'm trying to cram as much helpful content and information to help all of you get paid in this potential type of claim in the 30 minutes I can. So first, I'd like to start with a basic overview of an extended duration claim and talk generally about what it is. Essentially, any contractor who bids a project is going to put in the bid bidding for amount of time that they expect the project to take. What is the cost of the office overhead applicable to the project? What is the cost of materials? What is the cost of labor? Fundamental costs to be able to project out based upon the length and time and expenses, whether or not the project is something that can be profitable for the company and is something that that particular contractor is going to want to bid on. However, what happens whenever the project, which is anticipated, for example, to take a year, goes 3 years? Obviously, contractors up and down the chain are negatively impacted with increased material costs, with increased labor costs, with extended office overhead. So extended duration claims really are, as they're generally referred to as delay claims, seek to compensate the contractor for that extended duration of the project and for them to recover damages that they can get reimbursed for the project taking longer than it was anticipated to take, which was not within their control. Next, I'd like to kind of just talk a little bit about some of the potential elements of a claim. I mentioned a few of them briefly there. One, increased office overhead. Whenever you are bidding a job, you are not only projecting out what some of your hard costs will be, but this is something that typically may be referred to as a soft cost, which is your office administrators, your different project managers, people in the office who are devoting valuable time and energy to that project. If you're only initially anticipating them to be in that same time period example on a project for a year, and then the project ends up lasting 3 years, well, then you've got 2 years of extended office overhead on that project than what you had originally anticipated to have. Now, that is a very difficult thing to calculate. And we'll kind of get into that in a little bit later and some of the methodologies that are used to actually calculate that increased office overhead. But that's one potential element of the claim. Another two very common elements of an extended duration claim are increased labor costs and increased material costs. Obviously, your costs are not static in time. When you go and get quotes for different types of material, which you're going to be sourcing on a project, and what your labor costs today, those things obviously will increase just with, for example, inflation over time. So those costs may change. Additionally, if you just look at a current issue happening in our economy, if you had bid a project and you were supposed to supply a bunch of steel, which was coming out of China 3 years ago, and that project was delayed because of different tariff issues going on with that particular piece of material, that could have vastly increased your cost on that project if the project was delayed. That's a small example, but those two elements, increased labor and material costs, are common elements of an extended duration claim. And then there's some other potential ancillary and or may be included in a consequential damage category, damage items, which typically will fall into these claims. Some examples of that are loss of use, insurance costs. So you have insurance that you're carrying for a longer period of time on this particular project. in some situations, there may be a construction loan that was taken out, so that interest may be extending over a longer period of time and increasing your costs on that construction loan. Job trailer rentals, that typically will be a compensable element. If you were only projecting to have to rent a job trailer for a year and then you end up having it for 4, you have that differential in rent cost over time. And also sometimes there'll be some increased demobilization or increased remobilization costs associated with delays. So those are some of the other damages that typically may fall in the claim. Some may be present in some may be present in others. Those are the elements, general elements of the claim. And the next thing I kind of wanted to chat about and jump into this is how identifying a compensable delay actually works. And in most situations, that starts with a critical path analysis. And essentially, you're going to be looking at what was the critical path on that project, right? At the beginning of the project, for example, obviously the roofer is not going to be a critical path contractor, for example, in the first 10 days of a project. It's likely going to be, depending upon the project, maybe an abatement contractor, maybe the site work guy. So there's going to be at some point in the claim, if you're going to be successful, you will have to show that you were a critical path item and this is where the critical path was delayed and this is how it impacted you. And to do that, you've got to show on that path, on that plan, what the delays were and how you were impacted. One of the things I talked about, which I'd like to talk next about within that analysis, is understanding compensable versus non-compensable days. And this is kind of an issue which dovetails in with the critical path analysis because in many ways you need the critical path to determine compensable days, but there are also some days that are just non-compensable. A very common example of that is, a rain delay is typically in every construction contract and in every situation going to be considered a non-compensable day for a delay claim. Weather is just not going to be something that you're going to get compensated for. Now, at the same time, if you're coming up, you're part of the project, which is a critical path element of the project, is coming up and is delayed, say 50, 100 days because of something related to another contractor, the general contractor, or the owner, that is potentially going to be compensable. Along with compensable and non-compensable days, there does need to be an analysis and an understanding of force majeure. In a lot of contracts, there will be language that involves, that addresses a force majeure situation. What is force majeure? It's a fancy word to basically describe a situation which is outside of the control of the contractor and or the owner. For example, if there is a terrible lightning storm and lightning strikes the site and burns a lot of the work down, that is in many situations going to be considered force majeure situation, a situation that was outside of everybody's control and or ability to prevent, and not be something that you could likely find the contractors or the owner responsible for. Most construction contracts will have standard language governing that issue and talk about how force majeure is not compensable. And, that's probably a good point too for me to make at this point of the presentation, which is, when we talk about critical path and we talk about compensable and non-compensable days, and we talk about force majeure and a lot of the other things that we're going to talk about this afternoon, I feel like more and more I have to tell contractors that I represent, you need to read the contract because it all starts with your contract. And I know that seems basic, but it is a very thing that I've seen in the industry, at least in our legal community. It's a prevalent issue, is that contractors just sign the contract, don't ask about the language in there, don't look at it at the outset of the project. And unfortunately, the law in most states, I can only say for in Louisiana, is a contract is the law between the parties. And so a lot of these things will be in there, but I just use this also as a cautionary tale, and I'll talk about it in another context shortly, to always go back to your contracts, to have a good standard contract on file that you're using on every project that protects you, that you understand. And obviously, I think you should have a good lawyer on call to review contracts for you and give you advice on those issues. So we talked about compensable and non-compensable days, as well as a force majeure consideration. And that dovetails with this talk about contractual analysis into the next element of the presentation, which is contractual pitfalls to claims. These are sometimes the most concerning part about delay claims. And I think that for most contractors, if you are seriously considering making an extended duration or a delay claim, that you really need to get an upfront analysis from an attorney, reviewing your contract and giving you sound advice on whether or not there are some landmines in that contract. One common problem is going to be a requirement of it's called notice of delay provision. And this is becoming more and more prevalent in construction contracts. There's also been some case law interpreting this both at the federal and state level in Louisiana. And the delay notice issue is essentially this: a contractual provision which requires you as the contractor within so many days of knowing that you're being delayed to put a written notification of some form in, whether it be via email, whether it be via a letter that you Federal Express to certain parties. That is a common problem for many delay claims. And the candid reason is just that as a contractor, you're just out there working, and you're just trying to get the job done. You're trying to make money, have everything paid for, and build a good product. But a lot of times contractors don't look to the contract to understand that they have to give a notice of delay, and that can in many cases be a condition precedent which would potentially bar your claim. These potential delay notice provisions can come in many different contexts. And specifically when you're reviewing that notice of delay provision, it really needs to be read in concert with the general notice provision in your contract, because it'll probably be one of those two. Most contracts do have a notice provision where if one party feels like the other is in breach, they have to give them written notice, or to give them a curative notice for a curative period for them to cure the default. So those two provisions really need to be read together, but that is a huge landmine to many extended duration claims. You really need to look at the documentation that you have of it, or contemporaneously get advice from an attorney while the delay is occurring, and ask them what their opinion about the delay notice provision is and how it should be properly documented. In many ways, documentation, just like it's the same way for any type of lawsuit, is incredibly important in a delay claim. And this is one of the really critical elements, is really documenting a thorough and a well-known notice of delay letter, whether it be via email or an actual paper letter, depending upon the notices which are required in the contract, but really putting out a really lengthy notice and sending it as often as necessary. This can sometimes be a practical dilemma for contractors. They don't want other contractors they're working with, if they're a first-tier sub, for example, or other parties, to think of them as always ginning up a lawsuit on a project, or want to negatively impact the working relationship that you have with the various parties on a project while it's going on. But unfortunately, if this is in there, it's a legal requirement and you got to do it. And if you don't do it and you go to court and you file a lawsuit, or whether it be arbitration, state, federal court, at some point you're going to be looking at what's called a dispositive motion to potentially dismiss your case or lose it at trial based on the fact that you may not have complied with the notice of delay provision. Another contractual pitfall along this same line that you will find in contracts is what's called a waiver of delay damages. There is a recent U.S. Fifth Circuit case that from a couple years ago, which found a pre-construction contractual delay waiver to be legally unenforceable. The layman, quick, skinny on how it found that without really getting into all the code articles and legal analysis is that court found that because the damage had not yet occurred, i.e., the contract was signed before the project even started, that it was not enforceable. Now, will Louisiana appellate courts or the Louisiana Supreme Court follow that line of thinking and opinion? I don't know. I do think it will certainly have some element of persuasive effect on that issue if it ever reaches appellate consideration. I'm not aware that it has yet. But there are other types of waivers in Louisiana which are against public policy. For example, there's a specific code article waiving personal injury waivers for somebody to waive a personal injury claim before they get injured. That's not enforceable in Louisiana. So I do think that this could potentially not be enforceable, but the law is certainly not settled on that. And so it's certainly something you have to be worried about if you're going to really take into consideration making an extended duration claim, that you need to worry about if there's a waiver in there of that claim. Okay. Some other pitfalls to the claims. I don't want to get too negative here, but sometimes I like to warn clients about the issues. Everybody sometimes thinks that it sounds great to make a delay claim, and it can be if you're significantly delayed and you need to get paid for that. But it's just like anything in business, is you have to analyze both the negative and the positives of it. One important thing to really analyze with your legal team is which methodology you're going to utilize to calculate your office overhead. And so we talked about that a little bit earlier. One of the first calculations or methodologies that became industry standard was what is called ICLEI, the ICLEI method. There are some pitfalls in using the ICLEI method. Some delay damage experts will tell you that it's not necessarily the best methodology to use to calculate that office overhead. Another element with it that potentially could be a legal pitfall if you use ICLEI is that there is at least one appellate court case in Louisiana that I'm aware of and familiar with that says that there has to be a work stoppage for ICLEI to be appropriate, or for a court to allow that ICLEI calculation to happen. You can certainly be delayed without there being a work stoppage. And so in some ways I can be kind of reticent of a client using that methodology to calculate the extended office overhead because of that, that there's this case law out there just kind of making it somewhat problematic. But that's a discussion you want to have with your attorney and potential expert early on, is what documentation do I have and what amount of organization of that documentation do I have to ensure that we use the best potential methodology to calculate our extended office overhead. Another important thing, which could be a pitfall, is in any project where you have a bond involved. Great thing. And the reason to have a bond, most large commercial jobs that are public require it, and a lot of larger commercial private projects also require a bond to be posted. Obviously, the real reason for that to be there is to protect both the first tier subs all the way down the line, whether it be a material man, a laborer, an equipment supplier, that you want to be protected, that if you have to file a lien to ensure collection against that surety, that the general contractor is not going to just go out of business and you're going to be left there holding the bucket. The bond there really does operate as a protective device for everybody down the chain. And so you want to, within the lien period, whether you're dealing with the Public or Private Works Act in Louisiana, you want to ensure that you are getting your lien timely filed. You want to ensure that you've got all the necessary elements of your lien in there. And when at all possible, you really want to be calculating your delay damages to the best amount of number that you can approximate at least at that given time, and get it in that lien. The reason is, if you don't have that amount in the lien, then the surety is not going to be responsible for it. So you may only be owed $50,000 or $100,000, for example, in your base contract monies, but you may have $1 million delay claim. And if you only lien the project for $50,000 or $100,000, then the surety is only on the hook for what's in the lien, potentially. That leaves you in some situations with vulnerability if the general contractor is not a solvent, steady, large general contractor. You know, sometimes on public bid projects, there may be less contractors, not as many contractors like that. And so the surety analysis and ensuring that you can get that delay damage number calculated and itemized to some level of specificity as early on as possible will really do a good job of getting the surety on the hook for it and ensuring that you, from a practical standpoint, if you put together a good claim and win your claim, can actually collect money for it, which is the bottom line thing that matters. At the end of the day, you can get a judgment, but it's just as good as the paper it's on if you can't collect it. Okay. Next, I think is a super, super important, if not the most important thing to consider in making a delay claim or an extended duration claim, which is expert retention. This is not an area of law that you can go to trial on without an expert. You would be foolish to think that you could for many different reasons. Even attorneys who handle these regularly are probably not equipped to do the calculations, to manage the documentation, to do a critical path analysis, to determine which methodology to use. You really need somebody who knows what they're doing, who is good at managing documents, is good at knowing what to go look for and being as time efficient as possible. Because the bottom line is these experts are not cheap. My law firm, for example, we hire many different types of experts in many different types of cases. And I would probably say that, you know, a good delay damage expert, a good extended duration damage expert is one of the more expensive experts that our clients ever hire. And think about it, the reason is just simple. I mean, a lot of construction projects have a lot of documents. And so they're in the business of getting all the necessary documents, managing and organizing all those documents, and then reviewing them to take into consideration what caused the delay on the particular project, who they are alleging is responsible for the delay, and then calculating out all of your damages. You just can't do that without an expert, mainly because you need somebody to come in and give you a full calculation of that office overhead with a tried and tested methodology that would survive a Daubert challenge. A Daubert challenge is simply motions that get filed in different litigation matters seeking to exclude expert testimony either based upon their qualifications or the methodology that they use. And so if you have an expert who's not qualified and using an untested methodology, you're going to lose the case. So you really want to screen this expert. You really want to talk to them early on about what methodology they're going to use. Get as much information as you can about their experience and their pricing and how much it's going to cost. Get an estimate, budget estimates as best you can. And that will be a critical element of you deciding whether or not, from a cost-benefit analysis, you should move forward with this particular type of claim. And the last thing that I want to talk about is just some basic practical considerations in making this claim or deciding to make the claim. One, dependent upon your venue, obviously if you're in arbitration, you're not going to be in front of a jury. You're either going to be in front of 1, 2, or 3 potential arbitrators in a construction arbitration. If you're in trial, though, if you're in federal or state court and you don't have an arbitration clause, or the parties waive the arbitration clause and decide to litigate in court, you do have to make the consideration of judge versus jury. There's no right answer to that. You know, if you're in front of a particular judge who has a lot of experience in overseeing construction cases, you're probably going to want to go judge because while I do strongly believe in the jury system and while this may be a discussion which I'm interested in because I've handled these cases and I find them to be interesting and that you're interested in because this affects your bottom line and you making money and a livelihood, you would be probably not be surprised to know that 12 random people who get selected for a jury are truly going to be interested in talking about ICLE analysis and material and labor costs for weeks on end. So sometimes if you can, you want to go judge if the judge is well equipped to handle the case. And that's just my 2 cents on it. You could have different attorneys look at it different ways. Another consideration is to just be cognizant that the case will probably just become a battle of the experts. Most of the time, if there is a serious delay and it's been analyzed and there was a serious delay, the issue isn't that there was no delay. The issue is whether who was at fault for it. And one of the defenses will always be that they will, the other party will, whether it be owner or general contractor, will bring in an expert to attack your expert's calculations, to attack your expert's assumptions, and or potentially blame other parties for the delay to escape liability. That is just another reason that selecting an expert is such an important thing. I know I harped on that, but there are a lot of great delay experts around the country. This is an actual big expert industry where there are experts who do this all over the country, and you can really find some great ones, but you got to do your due diligence, because if you're a weak expert and then the other party brings in a strong expert, these cases many times are considered to be like battle of the experts. And last, we talked a little bit, a fair amount about it earlier, but the consideration of making sure that you have the surety involved on the hook. It's the same thing. You don't want an entity, if it's not a serious, viable entity, to not be able to pay your judgment if you're able to be successful in your particular claim. And when you have a surety there, you just have the level of protection that you're going to get paid.
Cool. Thanks, David. We got a couple minutes left here. If anybody has any questions, feel free to go ask in the chat. And we'll see if we have a couple of seconds here to touch on some things people are curious about. Otherwise, maybe we're kind of just going to wrap up here a little bit. Let me see. I was going to say, actually, you mentioned that you have to do due diligence to find experts around the country. Is there a go-to resource that you have kind of start that process?
I actually have, I think we have a booklet. I'm trying to remember if it's from which organization that I'm in that has like an expert directory. And they list some of them. I know some of them just from handling the claims and seeing some of the people in this general geographic area. But I wish I could tell you. I don't have it off the top of my head. Some of it is just good old Google searching, and there may be some lists sitting out there on the web for potential experts. There's a couple expert directory companies, which you could Google, and they'll have experts there. So a lot of it, I would say probably should start with Google. But yeah.
Cool. Any other thoughts here as we wrap up?
Yeah, so just in wrap up, this is a prevalent thing in the construction industry where there are compensable delays, and I hope I haven't been too negative about making the claims. They're just a very difficult claim to prove. And so you really have to have all the T's crossed and the I's dotted, because some of the elements of this are going to be reliant upon the expert calculating it. There's a lot of strong defenses to these claims, so you want to make sure your documentation is great. You want to make sure you got a great expert, and you want to make sure that you've lined it up really well if you're going to make this particular type of claim and be successful on it.
Awesome. Well, I guess that's just about all the time we've got here today. So I want to thank you again, David, for talking about this. It was great to have you.
Thank you.
And for anybody who has any questions about this afterwards, this will be available on our website within 24 hours. But if you have any questions that you think of later, or if you're watching this from on demand, go to the expert center at levelset.com/payment-help. Just ask a question, and then David or network of a handful of construction attorneys and other industry professionals around the country can give you some help to make sure that you get paid. So I guess that's all we've got for today. So thanks everyone for joining us.